everyone, welcome to HOA Fight Club. I'm Raylene Schiavano. Today we'd like to discuss the legislation that I'm asking for. So in Washington State, we have a very short session coming up. It's only 60 days. It always seems like we have a short session coming up when it ever comes to HOA and condo law. But so we want to make sure that we get in the amount of laws that we can to be changed to help protect homeowners. And we want to do this in the easiest way possible. So the legislators asked me to come up with my opinions on how I would see that happening. So what I did, and I'm going to share my screen with you so that you all can see. Let's share this. So I went to the legislators and I used the Constitution of Washington State to guide me. I started asking for things that I felt that would help us in the easiest way possible. So under the Washington State Constitution, of course, we know we should have all political power is inherent in the people. But I really have a problem with this because I don't feel like the political power is with the people in HOA and condo associations. But the Constitution is the supreme law of the land, which if you read that, then you understand that right now, HOA and condo laws or CC&Rs come above the Constitution of both Washington and US and above the laws. And then the Constitution and the laws come into place. We need to swap that. So we can't sign away our constitutional rights in Washington State. Now, in almost every other state you can, in a private contract, you can sign away your rights. Arizona, Washington are two of the states that you cannot sign away your constitutional rights. So be aware of that when you're debating with your legislators or trying to educate your legislators, because they don't know the laws. Even though they make the laws and vote for the laws, most of the times they don't know most of the laws. So it's kind of crazy, but they get bits and pieces. So they don't know a 139-page bill, what's all in it. It's really hard. So I asked for 6490, 405, and 6434, 304 for the enforcement of power and duties. Right now, it only says a homeowner has a right to be heard and impose so that board can impose reasonable fines. But we should not be fined unless we have due process. So in Washington State, first of all, you can't have excessive bills, fines, and punishment. And it can't be cruel punishment. Well, losing your house has got to be the cruelest thing I've ever seen and ever heard of. A board member can, fine you $50, add $3,000 worth of attorney fees, and foreclose on you in 90 days. It just seems like due process would really be advised in these situations. And for some reason, the legislators and the lobbyists and the attorneys, they all seem to think that we don't have the right to due process. And that's number one. I mean, that's a violation of our constitutional rights. No person's personal rights shall be deprived of life, liberty, or property without due process of law. So it says right here, without property, or our property, we can't lose that or have anything fines and all that kind of stuff. So it's right there in our Constitution. We should be able to understand that pretty simply. Another thing that I asked for is that if we're going to hold the homeowners responsible for a fine or a violation of the CC&Rs, then boards should be held just as responsible. So if a homeowner can prove, which is pretty simple most of the time, that a board isn't following the CC&Rs, that homeowner should be able to turn them over to the property manager. The property manager should fine them, and they should actually be forced to step down off the board, because a board of directors, that's their one job that they have, is to know the CC&Rs and to implement them fairly and equally. So we want to make sure that everything's fair and equal. If you're going to foreclose on homeowners, you should foreclose on boards because they are also homeowners. This is why I don't think there should be any executive privilege, any executive meetings. If somebody is suing the association, you have the right to know, because what happens is the board sues somebody for something you don't agree with, yet you don't even know they're doing it. And they're using your monies to do it with. So you need to know what your board is spending the money on. And you don't want their little spreadsheets. You want the actual bank statements, and you want the all the CCNRs, you want the financials, you want everything to add up, the invoices, the checks written, and who's signing those checks, and are they commingling funds? I have found that that the HOA was commingling funds with a property manager. If those property managers go into bankruptcy, so do you. If your money's going to a property manager, so make sure that the money is not commingled. We shouldn't be invaded in our space, in the private affairs of our home, which we don't have any privacy if you're in an HOA, especially a condo association. There is just no privacy. We have inspections all the time. It's worse than living in an apartment complex because you don't have, at least tenants have rights. We don't even have rights. As homeowners, these 5 or 3 to 5 board members can do whatever they want, and they can run it as a dictatorship. So we need to be very careful with that. The other easy change to the laws is the reserve studies. So no condo association should be in disrepair because it's required by the law for all condo associations to always restore promptly. Well, we have in the city of Kent, they do multi-housing inspections. So every 3 years they come in, they inspect the housing, they make sure everything's up to code, they make sure all permits are good, everything's good on the thing, and what damages there are need to be repaired, blah, blah, blah. Well, we should be doing that with HOAs and condo associations, especially condo associations. And the reason is because homeowners are already paying for those studies to be done. We're paying for reserve studies, which does an on-site inspection of everything. They go through all the stuff, everything, the buildings, the walls, the financials. So if a reserve person sees that there are red flags in a condo association, he should have to report that to the Attorney General and the city. It's not anything that's not being done already, and all they have to do is report. I think that would make things a lot better, and we wouldn't have so many water intrusion issues. My other thing is insurance companies. So the insurance of the association, of the condo association, is supposed to always come first, but that doesn't happen. So when there is a claim, it shouldn't be the homeowner fighting the association. It should be the homeowner's insurance company fighting the insurance of the association, just like it would be in a car accident. The homeowner doesn't pay for everything. Their insurance company covers everything, and the 2 insurance companies deal with it and fight it out, and they decide who's responsible for what. That's how this should work. There should be no board members involved. There should be an adjuster that's decided on by the 2 insurance companies. The adjuster makes the determination of who's responsible, and the insurance companies pay for it. If there isn't insurance, the association should pay for it automatically out of their pockets within 30 days. Leaving homeowners to suffer is just the most cruelest thing. Again, cruel and unusual punishment just because we're members of an HOA or condo association. That to me seems, to add the discrimination right there. We can only sue in civil court right now. So the laws do not allow for special or punitive or any other tort damages. And if there's a rogue board and a homeowner can prove that there's a rogue board and that board is using malicious intent, those should be thrown out and tort should be added. This is enough that homeowners should have to suffer in their homes by a rogue board, because there's no accountability or governance by our Attorney General's office. There needs to be something. We need an ombudsman. We need somebody that's impartial. We don't need somebody that's part of a trades group or trying to make a profit on the other side. We need somebody that cares for the people, that doesn't want to make a profit from the homeowners, that doesn't want to find them into foreclosure, that wants to protect their value of their home and knows what it's like to be in an association, not the attorney over an association and not the property manager over associations. We need to have somebody represent homeowners impartially. And, I've tried to do this. I've tried to tell the legislators what we need. I seem to find that there's a conflict of interest because somebody's pushing the CAI trades group, their agenda, which I'm sure they want to keep profiting from the homeowners. But as a person looking from the outside in, I don't see how attorneys can fight for legislation that gets rid of your constitutional rights. I just don't see it. And these attorneys keep telling you that you signed the contract. You didn't sign the contract. The CCNRs run with the land. The covenants run with the land. The Constitution is over that land. And those attorneys taking advantage of those laws for profit, they should be disbarred. at least turned in for ethics violations, because it is unethical. Anybody that wants to take a home in non-judicial foreclosure with a super priority lien has ill intent, and it's almost it's indefensible that these people want to foreclose on these people's homes without due process of law. So that is what I'm fighting for. I want due process added back. The corporations, which are associations in Washington state, they can only be formed under general laws, but they cannot be created by special acts. So special privileges and no law shall be passed granting to any citizens, class of citizens, or corporation other than municipal privileges or immunities, which upon the same term shall not equally belong to all citizens or corporations. Well, we know that these are very unconstitutional laws, in my opinion, and that is my opinion on that. You cannot give a corporation the special privilege to fine and foreclose on a homeowner with no due process. That is a special privilege. That's giving them they're allowed to create these corporations, allowing developers to write laws, not the municipality. Then they're trying to hand out speeding tickets and fines for things that they should not be dealing with. Our municipalities are very important. They were established for a reason, and we should go back to using those and throw out half these CC&Rs and have them redone. I think the state would be better off having all of the CC&Rs rewritten, or throw them out completely and have a set of CC&Rs done by the state. Maybe that's what we need to do. Just have one set of CC&Rs that the state deals with. Then the state doesn't have to play games of what the CC&Rs say with what developer and what he wanted to have done and how he wanted to hurt the people. Remember, CC&Rs are not to protect the homeowners. They're to protect the developer. That's what they're there to protect, not you. So be a part of your community if you're going to be in these communities, and know you're losing your rights if you are, but we are fighting for you. All right, I'll see you on the next one. Remember, these are my opinions, and if you'd like to subscribe, I'd really appreciate it. It really helps me. So have a good day. See you later.